Good afternoon, everyone.
Good
It is
afternoon.
my pleasure on behalf of the Committee on MSME and Startup ICAI to extend a very warm welcome to the 76th webinar of the MSME Pathshala Series 2.0. I am CA Numit Verma, your coordinator for today's session. Today, we delve into the crucial topic of intellectual property rights, basic of trademark copyright applications. We are honored to have our esteemed leaders joining us for the session. CA Gyan Chandra Mishra, Chairman of the Committee on MSME and Startup ICAI, who is a distinguished fellow chartered accountant, Central Council member of ICAI, and founder of the Gyan Ki Baat Foundation. We have with us CA Arpit Kabra, Vice Chairman of the Committee on MSME and Startup ICAI, a young, dynamic Central Council member of ICAI, and a tech-savvy problem solver. A special welcome to our speaker, CA Chetan G. Gatani. He is a practicing chartered accountant and working partner in Gatani and Company, who specializes in intellectual property rights services like trademark and copyright registration. Thank you all for joining us. Sir, over to you. Chetanji.
Yes. Good afternoon, everyone. Uh, should we start this?
Yes, sir, please start.
Yeah. The screen is available.
Yes, sir. Screen share.
Good afternoon. So, the what is IPR? The basic definition of IPR goes like this: ki, intellectual property is the property that arises from human intellect. Means it is from human creation. If there is any idea in the mind and it is not in the published or in actual form, it cannot be registered. So it is basically human intellect. And recently, intellectual property right have gained momentum and immense importance due to evolvement of the concept of startups, digital market, international funding, etc. That's why the need of intellectual property arised uh, in many parts of India and also in remote area. There are, as you can see, there are two types of intellectual properties. Uh, First is of literary and artistic work, which is copyright, and second is industrial property, which have subtypes like patent, trademarks, industrial designs, geographical indications, semiconductor integrated circuit, known as in acronym form is SIC, and protection of plant varieties. These are the subtypes of industrial properties in intellectual property rights. Uh, Now, why there was relevance and importance of IPR? Why the need was felt? Because as we can see, the patents, trademarks were established in 1990s. There means old act was there, but in recent areas, due to digital marketing, due to many startups and all online awareness, the need of intellectual properties was raised. So the basic idea beside this is the IPR is an intangible asset and it can be exploited by owner for a commercial gain. Uh, of course, the owner can stop manufacturing or trading of goods and services if there is any copied product or copied services or copied brand name. Then the owner of IPR, intellectual property right, can sell or license it out on royalty or rent basis for his commercial gain. Then as the brand is registered, we can have goodwill and value addition in the market to increase our sale and of course to increase our commercial gain. Then we get proper certificate from government after the registration, which is the valid proof of intellectual property. In the second slide, you can see the acts and provisions. like the Patent Act is of 1970, Design Act is of 2000. Earlier, I will inform in further slides. Ki earlier, uh, patent patent where means 2 to 3 patents were filed in 1990s and all pan India over the year. But now 30,000, 40,000 patent are filed in a year. That is the increase. Same is the increase in trademark and copyright. The Trademark Act is of 1999. Geographical Indication Act is of 99. Copyright Act is of 1957. So this is the basic idea about IPR. So first part is trademark. I have given some examples of known brand company for understanding. Uh, so trademark is it is done for word, name, brand, logo, any label, any design. For that, the trademark registration is done, which indicate the origin of goods and services, and also let us know key where is the customer or assessee is from, and it can distinguish the product or services from one and another. When you advertise it properly, it will create a good name, brand, and goodwill in the market to attract the customers. Just like you can see in the image, the Colgate, this smile, and the Colgate word, this R mark, everything is registered. Uh, you can see any in any products of Colgate. Then same Coca-Cola, this fat, this font, this circle, and the Coca-Cola name, it is registered. Same in TVS, they have also registered the image of this horse. One cannot copy the image of this horse as this is registered. And about trademark, go further. Trademark is the validity of trademark registration is for 10 years. After 10 years, there is the renewal process of registration. Some of the local trademark, which I will show in the further side, some of the local trademarks in remote areas we have registered on pan India basis. Uh, there are total 35 45 types of trademark registration in the classes. The first to 34 class number is for goods, either traded or manufactured goods, and the 35 to 45 class is for service sector, including our profession like accounting sector and all. Since our own logo, that is CA India, is registered, we cannot use another logo. CA India is registered for us. And for 1 to 34 exclusive classes are there, like for food sector class 30 is there, for clothing sector class 25 is there. These are some of the examples. Now these are some types of local city trademark we have registered, like aminofine. This is registered in chemical pesticides trademark criteria. uh, it is Faida Pay. It is just like Google Pay. It is registered in this criteria. Tesmo. It somewhat look like Tesla, but due to difference in some image, it is registered under this automobile sector criteria. This example MJ and Miraji Junior. This is registered under clothing criteria. These are some local remote areas example which are registered in some small cities and all. Karniti, this is registered under education criteria for tax planning and all, where sessions are taken for tax planning and all. You can see here the bow and arrow is registered in the logo form, and Karniti word is registered in the word form. So, as there are different forms of registration, trademark in trademark like word form and logo and label form. So we can take registration. Each class have each government fees, and each word mark, each logo mark is registered under different registration forms. This example you can also see like Pizza Hut. There is Bhakar Hut. Bhakar is the Maharashtrian word used for roti, flatbread roti. So this is also one of the registered criteria. Uh, this Chevrolet is registered under clothing criteria class 25. So these are some examples. So many of the goods and services registered. Doctor also get registered in this criteria. You can see the last image. The dental person has registered his name in this dental work. The validity of trademark is for 10 years. Up to 10 years it is registered. The process goes like this: ki we have to take legal search first of all, and then after legal search, if it is available, we have to apply it for registration in trademark. And uh, after proper registration, there is now there is time of 1.5 years for proper registration. If there is no objection from any party, or there is no objection from any government for the word or brand name which is used, so there is the final registration. It happen in 1.5 years, and after that it is registered for 10 years. If before registration the application shows the mark as TM. TM is temporary mark, and after registration we get a certificate of registered, that is known as R in that circle form, as you can see here. Uh, R in the circle form, and it is registered for 10 years. After 10 years, we have to re-register it by paying the available government fees. Just like for application, our for MSMEs, the government fees is 4,500. If the SSE, or if the person is non-MSME, the fees is 9,000. So there is clear-cut benefit of 50% in if the SSE is if the applier is MSME. And similarly for renewal, there is fees of government fees of 9,000 when the renewal is due. And after 10 years, if the fees is increased, then that we have to pay and get it registered for another 10 years. The second part is literary work is of copyright. If it is the protection that covers the published and unpublished literary work, scientific work, and artistic work. If we have the idea in the mind and it is not published in any form like software or book or any music or any song, so we cannot register it. So first of all, it should be in any published or any material format to get it registered under copyright. The copyright related to the exclusive and the bundle right for the original literary work, any dramatic or musical work, artistic work. Painting can be copyright. Photographs, just we see examples in India like wildlife photography. Many wildlife photographers register their photos. Films, movies, sounds, songs are registered. Software program is get registered so that it cannot be copied in the tangible form. Uh, so and the validity of copyright after registration is, say for example, for author, if the book is published, so on the day the book is published, after that 60 years it is registered, though the author is available or not, alive or not. 60 years the copyright is get registered. In some works the copyright is for 25 years, like artistry work and painting, the copyright is for 25 years. uh, I have given some comic example of copyright is like that, the copyright is not given for just an idea. For example, it is the example author of the book, say Five Point Someone is the book written by author Mr. Chetan Bhagat, and he has that story in his mind only, expression in the mind only, and he has only narrated that movie orally to the direct. He has directed that story orally to the movie director without any published form, and the movie director produced that movie named Three Idiots on the basis of the oral narration. Then the author does not have any right to claim that director has copied his movie and his idea and all. So first of all, he has to register or publish that book in the market for in the material form. So 5.71 is the book in the material form, and after that, the author has given the right to the movie director, producer to make that movie on the royalty or the sale basis. So, hence the copyright is the bundle of rights and can be exercised independently uh, by author and by purchaser. Unauthorized copying or copying of any book without any permission leads to infringement, and court cases and all will be there. So, in India, copyright protection is generally for the lifetime plus 60 years of the most literary and artistic work, and 25 years for many broadcast reproduction rights, where there is broadcast. Uh, um, Broadcast is there in media and all. There are the right is for 25 years. So example of copyright is one book is copyright that is known as a table book. It is for children, small children's learning the mathematical table. It is the type of some formulas so that the small children can learn table up to 20, 30s in fast process. So this is some handbook which was copyright recently. The next and long lasting is which is very time consuming generally, because trademark and copyright take 1.5 years to get registered without any objection. If there is no objection, if objection is there, then the case to case basis the time is increased. But in patent, generally it took 3 to 4 years of process to register the product, as the patent goes with its name key. It is for new invention, new technological process and new invention. For this, the patent is required, and there is a lot of study, research and development (R&D) we call that is required. That's why it take time to get registered. But during in last past 10 years, the patent is increased in India for many times. The latest statistics show that in 2023-24, 90,000 patent were applied with government of India for this for the registration, and most of them are in a successful stage. So you can see the definition. The patent is an exclusive right granted by the government to the applicant for his disclosed invention of industrial product or process which shall be new. The process should be new. This should not be any copied or earlier available process. Uh, and it should satisfy the patentable criteria under our law. Uh, the whole session, this is about India Act only. Means for other countries, US Act and other countries, UAE Act. This the law is different, and we are talking only about pan India basis. Pan India registration is. So, a patent offers technical solution to a technical problem, and in the lieu of disclosure of invention, the government provides legal protection to the original inventions which are new for the period. The patent is registered for 20 years, and after 20 years, it should be renewed properly. And also, there is a process of yearly renewal of a patent. Renewal fees should be paid for activating the patent every year. Some old examples I have taken, like Graham Bell phone and Bluetooth. Bluetooth of US has taken 20 to 25 years to get registered under patent. MACD foods, the junk food, the MACD foods we eat, that is also under patent criteria. Their food process and all, they have patented it. uh, Patent due to regular invention and all, patent has given the limited scope of 20 years for its time period for get it for its registration, and it has its territorial value key, the place where it is registered and what the patent criteria are followed, that is seen. Patent right gives protections against infringement and creates the possibility of assigning or licensing of the right, and enable the patent to take the legal actions against whom those who are copying the product. And patent is also sellable or giving right or license or what we called royalty if the patent is registered in the name of the person and he can sell or uh, uh, give on a royalty basis the rights of patent. Then in India, uh, in India in the last 4 to 5 years, many patents are registered and already doubled from 2014 to 18. Patent ratios is doubled. Recently, SRM University Chennai has patented its one device known as Earthquake Research Cells (EQRC). Recently, they have registered it for earthquake research. um, One educational institution, Academy of Higher Education and Research, have patented the product of one medical device and dental device, which was got patented in India. Many medicinal products in India are registered in Make in India system are in the patent form. Uh, the next part is the next type of intellectual properties rights are industrial design. Um As you can see in the example, the design means only the features of shape, the proper shape of that bottle and all, configuration, any pattern, any type of ornament, design, any composition of lines and colors. And it should be for that particular article, proper design, unique design should be there, one dimensional, two dimensional, three dimensional under industrial process, and it should be judged by an eye. It should not be any uh, public against the public image or any obscene or scandalous matter that is not get registered under industrial design. So proper benefit of public at large products are only designed under and are protected under industrial designs. You can see in the image the bottle shape, Coca-Cola shape. This shape cannot be copied by any of the competitor of Coca-Cola. This is registered under industrial design. Same this logo of M and this is registered under industrial design. Some examples I have taken is any lead of box, just like parachute oil box. It is that lead is registered under industrial design. Like that, iPhone phone or Samsung phone, they have registered hundreds of their products under patent, trademark, copyright in many classes, industrial design. Many of their shapes, phone shapes are registered under industrial designs. um, you can see on the road Volkswagen Beetle car, Mini Cooper car, that two-seater Beetle car, green color, yellow color cars are seen very often, that are registered under industrial design. That designs cannot be copied by any of their competitors. Fitbit tracker, one tracker watch is there of Fitbit companies that is under industrial design criteria. Many cameras are there, kitchen appliances are there. These are registered under industrial design criteria. Uh, the next and very widely used nowadays, which is registered for, which is used in a with a group of person like farmer producer company or a particular place, it is registered, that is geographical indication. GI, we call it in common parlance. GI, geographical indication, refers to the indication that identifies the goods originated from that particular place. The reputation of that place or the characteristics of that goods is particularly attributable to that location. It is location specific. Some common examples are Darjeeling tea, Basmati rice, Kanchipuram silk, Nagpur oranges, the marbles from Makrana. Recently, our honorable PM has introduced one, had done the opening of one shawl type clothing handicraft material Gamosa in Assam. Mm, Recently has done the inauguration of that in the government and Union Ministry of Commerce and Industry have taken oath or have targeted to take their the geographical indication to 10,000 in 2030. They have recently informed in that GI Samagam held in New Delhi last year. Um, they have targeted to do 10,000, which are recently there are 3,000 or 4,000 geographical indications are there in India. Mm, in 2024, you can see in the example, in the Gujarat, the Kutch part, Kutch Ajrak is one type of textile craft or shawl was introduced, and it was honored the geographical indication tag, the Kutch place. The Kutch Ajrak is the name of that textile material, and Kutch is the place. The GI has five parameters mainly to get the registration. The first parameter is of originating from a, it should, the product should be originated from that particular geographical area. That should, second is that that should have linkage with that geographical area, either direct or indirect, but the it should be from that place particularly. The why it is manufactured or why the product is from there, we have to prove that. Then reputation of the product, local, in the national level, locally how the product flows, or international, that is also taken into consideration. Past historical origin of that product is also taken into consideration while registering the geographical indication. Then and the last is uniqueness and the quality of product, whether it is properly used for public or not, or it is it affecting the have bad influence on public, that is also checked. So for the beneficial of public at large, it is taken into consideration, and then the geographical indication tag is given. Now, mainly the GI tag is given for handicrafts and foods purpose, to make that place as a good tourist place, to be that place to be a proper value added place in India. Uh, the benefits for GI is for that particular place to be a that place should be known to everyone. That's why GI tag is important. Some new examples of GI tag is that in Andaman, some type of muesli rice is produced, that has got the GI tag. In Banaras, some type of a cold drink, Thandai cold drink was added as geo tag. In Assam, Bihu language, Bihu peoples have registered a Bihu dhol, one type of musical instrument in GI tag. Like this, there are many example in Maharashtra. There is one type of coriander known as Kasti coriander, that is registered in Maharashtra. And then in Uttar Pradesh, some crafts item like Amroha, Dholak, and Sambal horn craft are registered recently in geographical indication criteria. The next and very less used, mostly this part is used mainly in many corporate sector or technology sector or automobile sector, big industries. These get registered, which is known as SIC, Semiconductor Integrated Circuit. Common examples are like that I3, I5, the chip, microchip in the automotive uh, vehicles and all. These are semiconductor integrated circuit. So, SiC means a product having transistors and other circuitry elements which are inseparably formed or inside any semiconductor material, insulating material in the electronic and circuitry functions. Examples is microchips, IC chips, in CNC machines, mobile phones, computers, etc. Electronic watches, the machines in the watches, in the mobile phones, these are under semiconductor integrated circuits. The layout design pattern is registered in this SIC. The electronic layout patterns is registered, uh, and this registration is for 10 years. 10 years it is valid, and after 10 years you have to get it renewed. The next is protection of plant varieties. Now, for as we are in the Make India project, we are producing many medicinal things or herbs like things which are useful for public in India, public and animals too. So this need of protection of plant varieties was added, and this is now booming in the agriculture sector. So in order to provide an effective system of production of plant varieties, uh, and to protect the rights of the farmers and plant breeders, to encourage them to produce new varieties of plants which is helpful for public at large. This IPR was introduced and is booming nowadays, uh, which shows the new and genetically good plants or herbs which are used for medicinal purpose or which are used for any betterment of society. This agriculture protection right was introduced to develop the new varieties of plants. Such protection is likely to facilitate the growth of seed industries in India. Many new types of high qualities of seeds which are helpful, which does not have which does not require any harmful chemicals or fertilizers. High quality seeds are there, and planting materials are there which are useful. For this, the plant protection of plant varieties was introduced to boost that market. Protection of plant varieties gives 20 to 25 years of protections in case of trees, plants, and vines, which are used for 20 to 25 years of life is there. After that, they have to re-register or reinvent the plants. For this protection of plant varieties, the office is in Delhi DPS Mark. There is office head office of this where the protection of plant varieties get registered. So these are some basic types, as you can see from first slide. These are some basic types of intellectual property rights in which SSE or the person have to register. So generally, trademark and copyright for in MSMEs on in Pan India due to many classes in trademark and copyright. This is registered mainly and practiced regularly. Means on an year basis. Um, you can see the statistics like this key on the yearly there are 30,000 to 40,000 trademark applications are done in various categories. So this due to less time constraint like 1.5 hours, 1.5 year we can get the trademark registered properly. So many of the persons or individuals or companies registered their brand name. So the process for trademark, as we consult or we practice in this key, the process of is goes like this. First, we take the legal search in the application. As the server of this trademark registration, it is done on ipindia.gov.in on this website. As the server of this is situated at Vienna, so it goes to Vienna Codification Center for checking that the application we have applied is copied or not. So first we have to take legal search. Then after, if the search is positive, we can make the application of the trademark by paying the government fees, which is 4,500 recently for currently for MSMEs and 9,000 for non-MSMEs. After application, there is 1.5 years time for getting it registered. So after application, we can see the status is formality check pass. Means in this time period, the government or the authority check the legality of our applications, our papers, our documents. Everything is checked on application, just like our KYCs are checked, the applicant name is checked, the power of attorney holder, legal who has applied, that is checked, the form is filed correctly or not, that is checked. If there is correction, say for example, if we applied and we thought that after application key the proprietor name was mistakenly written, husband name we have to write, but we have written wife's name, or any pan mistake is there, then we can there is error, we can file the form T, trademark modification form for clearing the errors. If we don't clear the error and the formality, instead of formality check pass, the error came from government, that is formality check fail. Then we have to check the reason why the authority has mentioned it as formality check fail, and we have to clear that clerical error or manual error by paying 900 government fees, which is currently the government fees for trademark modification. After that, after all the errors are satisfied, after formality check pass, it is marked for exam where all the papers and documents are checked. Government authority has authority gives the time for to the people in India at large to check whether the applicant has copied your name or not. The time is given. Earlier, it was 6 months, was due to large number of applications and due to I think due to less manpower in whole system. I think the time has increased. And also the applications were increased so that the time is increased in trademark registration. So it takes 1 year to for mark for exam process. After the exam, after they mark the exam is okay and the product is okay, then the exam report is issued. In between, if any objection is taken and we have not replied to the objection, then there is rejection. If the objection is taken and we have do the counter object and all and authority is satisfied, then it shows as accepted. If no objection is received, directly the process is under accepted. If in 1.5 year no one has objected, any third party or authority itself has not objected our product or our service, then directly we get the accepted status. After acceptance, it is advertised before acceptance on the online journal, just like we have our ICI journal. This is there is journal of trademark where yearly weekly they post key who had got registered and all, and the status shows as accepted and advertised. Advertised before accepted shows only the advertisement in their journal, and after that, accepted and advertised is shown. In between this process, anyone can object in accepted and advertised process. Anyone can object. Means accept after accepted and advertised also opposition can be made, but generally after accepted and advertised, it is seen in common parlance कि no one object after accepted and advertised, because it will take time, court cases, money, time will be lost. That's why after accepted and advertised, generally it is seen that no one do the opposition. And 1 to 2 months after accepted and advertised status, we get the trademark registered, and we get the certificate in the format of registration where we can use the R mark. The process flow, just as shown in that flow chart, is like this: sent to Vienna codification, where the Vienna code classification is an internationally accepted standard for logos and different element it contains. We can see when we apply for registration of private limited or LLP on the MCA portal, we have to also check from trademark registration if the name is copied or not, and we cannot get the name if it is already in the registration process. Though the trademark is registered by individual or any proprietor, where single person has registered the trademark, but the name of the company or LLP, we cannot get the name approval if the trademark is registered in any name. So hence this trademark is very important nowadays. Uh, I have explained about objections. So there are two type of objections. Section 9 objection, which shows the absolute ground for refusal of registration. It shows that if trademark are devoid of any distinctive character, means any wrong word or any generic name is taken, or say for example any god name or god image is used, which hurt the sentiments of public or which is not good for public at large, which cheat or deceive the public or create any confusion. These marks are refused by government under section 9 by the authority. Just like No one can copy our ICI logo, ICI India logo, or any national emblems. No one can copy this. If anyone found, we can government itself take authority itself take the objection under section 9. And section 11 objection is for third party objections where government or authority has marked it properly ki this brand or logo is available for registration, but third party has in the period of 1 to 2 years has claimed that no, this mark is our and this identity is our. So they have to do the objection by applying online on their portal with proper valid proof. So section 11 objection is for third party objection and section 9 objection is for authority objection. Uh, The next is ipindia.gov.in website. Now the website is renewed and we get a proper color format. This is old format. We get this is some oppose. You can see the status that applied on this date and the status is opposed for some application number XYZ. You can view the examination report. You can view here what documents we have uploaded. If we want to take objection for our SSC client or any individual for our personal practice, client in our day-to-day practice, we also can take objections on this website. And this history is shown ki where, when that application is made, when it came in journal, what notice has taken, what we have, what replied, what evidence is given. Everything is shown on the website. Then it is also seen ki who has opposed us, what opposition has been in the detail section. We can check what they have, what objection they have. So this is a screenshot of that opposition mark. This is the earlier it is black and white certificate format. Now the color format is available. This is the final registration mark. This is the type of registered certificate where R is used. See, for example, it is registered under flexible pipes criteria in class 17. The second page is shown is shown. This is the first page where details of trademark and all is shown, and the second page is the mark, which mark is registered, either logo or word mark is registered. That is for second page. Date is mentioned, so that we can check the renewal procedure and all. This is the rectification file. In the last slide, I have shown ki by paying 900 rupees, we can apply for any rectification. So this is the rectification slide. This is the status of that rectification where we can check what rectification we have to done and what is the status of that procedure. If we as a legal procedure, if we have to take the opposition, this is the procedure. If for any registered product or we can see the anyone has copied our product, we can take the opposition like this. If first we have to send them notification in a proper legal way, then we have to apply to the authority by paying proper government fees for opposition. Then the opposition party will send their counter statement. The time is given for them. Say, for example, 90 days is given for counter statement. Then our counter statement is made. If we think that his counter statement is not satisfactory, then we can make our statement. We can give our evidence. We can prove that we are using the product and it is copied by, we have registered that product or we have used that product from many years and someone has copied that. Then hearing is there, just like our court, high court or like that. The bench, three bench judge is there for registration. That is done. These are the steps for oppositions. Some one example of opposition is given. This is search report. The process, first process where we search that trademark is available or not, and department shows us the search report like this. Key, this name is available, registered. We cannot take this name. This is one type of example of search report. So the this is the this is the basic ideas about trademark. Same goes for copyright. Copyright, we have to register. We have to, if for example we have to publish any book and we have to copyright it. So first we have to after application we have to send the sample format to three trademark office, Mumbai, Bangalore, and Delhi. And after that it is get approved and we get the copyright certified, and the C in the circle mark is there if we want to get properly legally registered for copyright. uh, in copyright and trademark we get 1.5 year time to get it registered. uh, Same like patent, there are many research forms. We have to prove to the government that the process is uh, we have to prove to the authority that the process is new or technologically sound and innovative, and it is not copied by with any country, or any formula is not copied, and then we get the patent registration. uh, Now, for MSMEs, the benefit is mainly for the cost of the trademark, copyright, or patent, which is half. Means, say for example, if patent cost is 2 lakh rupees in normal cost, then for MSME it is half. In trademark, 9,000 to 4,500. This is the main benefit for MSMEs. Um, of course, in the remote area, due to proper digital awareness and all, trademark is booming. That's why good for MSMEs in local areas, in normal area, in official area, where we can register our goods, our practicing our services, I mean clients, goods and services, to increase their brand name. Earlier, it was used for brand name in many corporates industries only, but now brand name can be registered by local person also. So MSMEs, these two benefits are there for maintaining goodwill, for creating own brand in MSMEs. This trademark is very important. Next, for franchisee model, trademark is used. Say, for example, in Maharashtra, Yevle Chai, most of us we have heard about that Yevle Chai. It is a tea stall, normal tea stall who have registered its brand, and now is giving many franchises outlet. Means his source of income is of that tea vendorship, plus also the franchisee royalty income or franchisee fees they can take. uh, Many food industries have their franchisee, many automobile sector have their franchises model. So that is also beneficial for MSMEs to start own business and give franchisee model after registration. Uh, if we get registered under this industrial design or trademark criteria, angel investor, foreign investor also get attracted to invest in our company. We can also see that in media, in that Shark Tank India and all, they also check that your product is registered or not before investing. So many of these get importance and registered under IPR. The next Now the forms, practically the forms are like that. Ki form 48, form 48 is for power of attorney. If we go for registration for our SEC client or for individual or companies, we have to take the power of attorney, just like we have to take in our income tax cases and all, about power of attorney, about ki they are authorizing us to do that consultancy or registration work. Then various forms are there for applications, for rejections, for taking objections, uh, for this. And after paying proper government fees, the application is done. Uh, Before renewal, our the registered email ID and mobile number is shown in the application is very important, because if there is any renewal process, then authority intimate us that on email ID or mobile on our SMS, the renewal is due, you have to get renewed it as earlier. So that's why registered email ID and mobile number is important. We cannot use any random email ID or mobile number for our safety purpose. Then Documents required are, of course, KYC, PAN, Aadhaar for proper name and all. Business address proof is required for this, uh, for copyright, trademark, and for patent also. For individuals, PAN or Aadhaar is sufficient. For corporates, companies, private limiteds, or LLP partnership firms, Udyam registration is must, beside KYCs of partners and beside PAN of the entities. MSME registration, Udyam registration is must. For individual, Udyam registration is not required, but generally we should take so that we can understand that it is under MSME and 4,500 benefit is there. And for logo, we have to take proper Coral Draw or proper legal JPEG image, so that the image should not get spread in the pixel. Proper image should be there so that it is registered properly. Uh, So this is about trademark, copyright, patent, and all IPR, which are available for MSMEs and for public at large to do the registration. Uh, if any queries and all, we can take in the session, because this is the theoretical part, and there are many practical approach to that. There are many practical queries related to this, so that we can solve it properly.
Yes, sir. We have a few queries. Just
Yes, sir.
just give me a few minutes, sir.
We have received few questions. Am I audible, sir?
Yes,
Okay.
yes, ma'am.
First one, explain the main categories of IPR recognized in India.
Main categories of IPR recognized in India. I have explained it that these categories of IPR is in Indian Act only. That copyright, patent, trademark, industrial design, geographical indication, SIC, and protection of plant varieties. These all categories are from India only. It have registered under Indian Act only.
Okay.
So.
What is the role of the Controller General of Patents, Designs, and Trademarks in India? CGPDTM.
Okay, CG. Okay.
PDTM. One of the
Uh,
participants raised this question.
Role of that.
Yes,
Uh,
role of Controller General of Patents, Designs, and Trademarks.
okay. That is authority for registration, means role of what means what I have to explain key, what they do like that.
Yes, like that.
They are the authority, and means checking all the process is copied or not, everything that is registered, the controller can do, no, means controlling this registration process and all litigation parts and all.
Concept of a distinctive mark under trademark law?
Distinctive.
Yeah,
Yeah.
concept of
Uh,
distinctive mark under trademark law.
Yeah, distinctive mark means first and foremost, it should not be copied or exact similar. Some distinguishing or some innovative thing can be there. Means logo. Say for example, we can take the common parlance example. Say Reliance logo, R logo. The same cannot be copied. Or we can check just like I have shown in the example, the Tesla T logo. That Tesla is somewhat different, and was also different. That's why we have got the registration under that red T mark. Like that, the distinctive mark should not be exact copied, and that distinctive mark should not be any wrong or bad influence logo or mark. It should be applicable in the public interest.
Role of TMA in the trademark filing process.
PMA is the application form, means the first
Yes.
form for which we do the registration. The rule is key. We have to file proper TMA. There should not be any error. After, of course, for error, the clerical form is mistake form is there, rectification form. But in the first go, we should apply properly trademark form, mentioning all our details. And first and foremost, email ID and mobile number should be properly mentioned because any notification will be shared on that only.
What is WIPO and how does it support IP protection globally?
IP production, that is World Organization for supporting trademark in India, US, or many countries. Just like we have DTA, like that, WITO is working, and it support for common trademark. Means any foreign countries have to register in India or Indian registration have to go there. The WITO is beneficial.
Okay. Trademark opposition and who can file it?
Trademark opposition. So the trademark opposition can be done on a legal basis. So currently the authority is given to practicing CS having agency code and advocates having attorney code. So they can file the opposition. Our SSC or client who want to make opposition can go with these two professionals. As a CA, we can help them in a consultancy work proper.
Okay. So you feel it is a good area for practice or
Yeah, I feel it is a good area of practice. I'm working it from last 10 years. So for consultancy work, it is very good for practice. Yeah.
uh, role of that is gone? What documents are required to file a trademark application?
Yeah, I have informed that the documents for individual, mainly PAN and Aadhaar as a KYC to check its individual name properly and business address. And for other entities like partnership and private limited, their registration certificate plus KYCs of partners, directors, and Udyam registration is compulsory required for entities other than individuals. And rupees 500 power of attorney is required. On bond paper or stamp paper is required to authorize us or to authorize the legal person to act on behalf.
What is the significance of a device mark or logo mark in trademark registration?
Yeah, in trademark registration, the logo mark is termed as device mark. Device means logo. The significance is that if any name is in a common criteria or common parlance, it is used. So it means generic name, which is not under. We do not get any registration for a generic name. So we can design a proper logo in, say, for example, the name, my name, Chetan Gattani. In common parlance, it is not get registered, but if we design any logo like CG or any circle, in that circle or diamond form, CG I have written, or any tagline I have written in the logo form, which is known as device in trademark language, that we can get registered. So if we want to register our brand name or any service name, we can design a good logo and get it registered properly. And nowadays, due to AI, yeah, pardon. Nowadays, due to AI, we can also check the images are copied or not. Means we can take the search of images in AI. We can browse it our images from our laptop, from our computer, and we can check that image is copied or not. Earlier, it was not possible because there was no such mechanism, but now it is possible to check images also.
Okay. The Madrid Protocol, and how does it help Indian business in global trademark? Madrid Protocol.
Yeah, Madrid Protocol. One second, I
Can
have
you
that.
explain this
Copy.
Madrid Protocol first, sir?
It is Madrid Protocol is of course the international system of protocol, just like earlier Veto you have discussed. It is a single application for registration from that country to India for and multiple countries. This protocol is used, Madrid Protocol, and that what we check is. Um, World Intellectual Property Organization has given that Madrid Protocol rights for the registration, international, global registration.
Global registration. That
Mm.
means that if we
Uh,
file the
Means for
application through this
yes,
Madrid
yeah.
Protocol,
So for simplifying the process means in India there are 45 classes. To for simply the foreign countries have not to register under all 45. They have to pay the fees as per that 45 classes. But the process is simple. Means in single form they can apply from this Madrid Protocol.
so it like one of the participants is asking,
Yeah.
is it possible that a businessman in India can get it registered and this through this Madrid Protocol, it is registered through the participant countries?
Yes, the countries, if they are looking for, if it is in that Madrid protocol,
Otherwise, like
they
we have
can apply
to
for.
get it registered in every country. Suppose I have
Yeah,
a
yeah,
copyright thing, so can
yeah,
I
yeah.
get it registered simultaneously with the other countries also?
But we have to check the protocol for that copyright. There is another protocol. This is exclusively for trademark. For copyright, another protocol is there
Okay, you can
for
explain it
patent and
via
guideline.
trademark only. Let
Yeah,
it
yeah,
be
yeah, yeah,
trademark.
yeah,
So
yeah, yeah. We can if the countries are covered. Say for example, 10 countries are covered in the Madrid protocol. We can register in that countries. Uh,
okay, that
Many
means a
protocols
single
have.
application and the registration will be in those 10 countries.
Yeah, yeah.
Am I right in
Depending
saying
on
this?
which countries you are doing, the fees or the structure will be from country to country.
So we'll be talking
Means
about
there is
it
no common fees. Yeah,
right.
yeah, yeah.
What type of works are protected under the Copyright Act?
What type of pardon?
Works
Pardon.
are protected under the Copyright Act.
Okay. Can I share the screen again, or can I show this?
Yes, yes.
This. So, one second. So, in the copyright, you can check key original literary work like books and all, dramatic work, any movie, song, musical work, artistic creations. Many paintings are registered, any designs are registered, photographs are registered. I have given the example of wildlife photographies. Many wildlife photograph have registered there in the copyright. Many films are registered, sounds is registered. Software program, any software app is there. We have that non-disclosure agreement with the software owner, but that program can also get registered. Their flowchart can also get registered in that tangible form.
Can
Yes.
copyright exist automatically without registration?
Yes, copyright for books and all, for the published material we get, it is copyright. But for our protection, we should take copyright registration to get that C mark and all, so that we can claim if anyone copied the product. Just in many times we check in our Indian industry, we check in our movies and all the stories of the movies are copied. That's why it should be protected. Many cases are there. Recently, we have seen in many cases like that. Like voice of Amitabh Bachchan that cannot be copied. It is copyright like that. Example.
Okay. Difference between economic rights and moral rights.
No, no, I don't get it. Economic rights. Huh?
Even I didn't get it, sir. Okay, we can
Yeah,
move to the next
yeah.
question. What is the procedure for filing a copyright application and what documents are required?
Yeah, same like TMA form, there is copyright one form is there for application, and same we have that power of attorney KYCs of the individual or author or any entity. The documents are required. Plus the we have to the book or what thing we are getting copyright. We have to take the three samples and we have to apply to the registered authority in Mumbai, Delhi, and Bangalore for that to get it approved. They checked it. Earlier, there was a CD format. Say, for example, book is there. We have to give them a CD format. Now, CD is not outdated. That's why proper hard copy is sent to get it registered.
What is the process to file and register for IPR?
No. Process is the same. ipindia.gv.in is the
Final
website.
application and all.
Yeah. The basic site is common for all ipindia.gov.in.
Can you kindly guide us with the process flow of how it should be a practical walkthrough when we have to apply for a trademark?
Process flowchart I have shared earlier. Uh, Flowchart I have to check na ki what is the procedure. What question is that?
Yes,
Procedure.
the
Yeah.
process flow. What is the step one, step two, step three?
Yeah. 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 You can show again.
You can simply dictate and they can note it,
Yeah.
whosoever
Yeah.
question it is.
Yeah. Yeah. See, in a simple, we have to first procedure in a flowchart way. Ki we have to first legally search that if it is available. We have to legally search on ipindia.gov.in. If it is available, then we have to apply for registration by paying the government fees as applicable, and then it is marked. It is marked to the authority for checking. In the form of formality check pass. After formality check pass, it is marked for exam, and after mark for exam, the time is given for objection and application. Means approval. If no objection is taken in 1 and 1.5 year, then approval is granted and trademark registered is certificate is received. So before that, there is provisional registration until the process completed. There is provisional registration in the form of TM. Temporary mark is used for any product or service. After registration, R is used. So this is the simple flow chart. But due to many applications, the time is increased. Earlier it was 6 months. Now it is 1 year or
One
more.
year.
Yeah.
It is regarding valuation, sir. How does valuation of a trademark is different from valuation
Yes.
of goodwill?
Yes, that depend on valuation. That valuation depend on that formula based. Just like we have our valuation course in the institute, that intangible asset is also get valued. Depends on the future value or projection value. How that mark will increase your turnover, or how that service product can increase your brand value. On that basis, the valuation is done. Registration and process amount is normal, means in very common less amount, but valuation in a bigger way futuristic due to that registration, how our sale get affected in positive way, that is calculative and that can be valued.
So, what is the fees for these different kind of registrations? Like for a trademark, the fees is for MSMEs, you told it is 45.
Yeah, yeah,
What is it
yeah.
for a copyright or a patent, sir?
For copyright, it goes from depends on that work or artistry. It is one from 1,000 to 5,000. Fees is there, and for patent is stepwise. First, we have to give the research, then research amount. Then after the research is approved by government, then we have to prove them this product is innovative. Uh, then there is another government fees. So first initial fees is 10,000 for application of registration. Then again 15,000, 25,000. Like go with the work. Common fees is for trademark, which is widely used because of its nature, product and services. So 4,500 and 9,000 is the common fees for trademark. So it is not stepwise fees for trademark. We have trademark fees if objection is received. Then if objection is received by government, then 900 rupees. If objection is received by third party, then 1,600 rupees for answering that objection. Means counter statement we have to file, paying government fees. But for registration process without objection, there is simpler fees, 4,500.
Can you please explain again that IPR related to plants and seeds?
Okay.
That slide.
Yeah. See, plant plant varieties, protection of plant varieties is for development of farmers and agriculture sector at large, where uh, where uh, where the right is protected if the group of farmers or individual farmer manufactures or what we call breed the new variety of plant which is useful for public or animals at large, which is medicinal herb or any plant which is useful for us, for people, where it have medicinal value and not any wrong consumption value. It should have good value as a medicinal purpose. For that, this protection of plant varieties was there, and due to which many high quality seeds where chemical items are not required, where chemical fertilizers which are unapproved or unhealthy are not required. For that, protection of plant varieties was introduced.
Can you
Here,
give some example?
many medicinal plants are used, are under protection of plant varieties. Group of farmers, like farmer producer companies or group of farmers, produce, say, medicinal tulsi herb plant, where genetically new tulsi was produced, which is important in many medicines. Um, Many, and one more thing, that menthol plant which is used in medicine for many health related things. For that, protection of plant varieties is used. And the first thing is, for medicinal purpose, this was formed for new plant varieties, and good qualities of seeds should be produced. And it is related to consumption. That's why human consumption or animal consumption. That's why it is given the medicinal value.
Can an individual get this registration, or it has to be an FPO?
uh, Individual can also register, and FPO can also, both can register for protection of plant
Okay,
varieties.
there is no bar on the
So
same.
there is no bar, but generally it is seen that we have to prove them na, ki it is medicinal and it is good for health. Group of farmers and right of farmers come together to make this.
So, what will it be called, sir? Like, it is a copyright or patent, or what is it called?
No, that's why this separate na protection of plant varieties is there. Copyright and trademark is for copyright is for any published material. This is not any published material. Na, this is produced.
I,
So
I
if
just I just wanted to know what is it?
uh,
What should be the title
yeah,
for it? Like we
yeah,
have yes.
uh, say any new medicine or new plant varieties they have purchased, so they can register under protection of plant varieties to get
Okay, this is the heading they are
beneficial.
given on the
Yeah,
website.
yeah, yeah,
Under that heading,
beneficial.
you have to
Yes,
apply.
yes.
Okay.
There is beneficial for any subsidies or any cost related benefit is there. Any funding from government is there if they are registered under this protection of plant varieties. And for the product, if they have given any name, that is under trademark.
Okay. So
Right.
what should be the list of documents or information the applicant should have before filing the application for registration of protection of plant varieties?
Yeah, basic documents are same, KYCs and all. And in protection of plant variety, just like patent, you have that sample research and development, quality check, and all should be there, where research and development procedure is shown and the product is uh, means healthy or not, it is proved.
Okay, maybe some sort of
Definitely,
agriculture
yeah,
university
it is just like
certificate,
patent ki,
maybe.
it is just like patent ki technical part is there. Means scientific study can be done.
Okay. And can it be used for the products? Like, for example, if a particular person is producing a specific quality and size of mushrooms, can it get it registered, or it has
Yeah,
to be a
it can
process?
get it can get registered if it is new, means it has any genetic proper value. That's why.
Okay. It has to be a
Then
genetic.
it comes under yeah, it comes under protection of plant varieties. If that say for example dragon fruit, it comes from China, but if it is at good value of protein and all, so it can get registered under protection of plant varieties in India. Many Indian farmers are producing dragon fruit nowadays.
You must have heard about this Zespri brand for this kiwis. It is a New
Uh,
Zealand
uh,
brand. So,
uh,
if some farmer or somebody want to get his or her product registered, like any fruit or vegetable, so what should be the process?
means farmers in India.
Yes, farmers in India.
I have to. I have not got your question. It should be means that brand.
There is a brand called Zespri.
Yes,
Zespri.
yes,
It is a brand for
uh,
kiwi. You must
yes,
have known this.
yes,
So,
yes,
can we get our products registered like Zespri?
uh,
That is a New Zealand brand.
yes, yes. I can see kiwi fruit. Na, yes, we can
Yes.
register our, but it should add that value. Na, it should not be same as that. If it is adding any value as a medicinal value or as a proper consumption value, then it is we can get registered.
Okay. Let's move to next question. So wait a minute. I have to see if there is any other question coming. Okay. Can we patent a business model or a process?
Hmm. Business
Can
model
we
or a
get
process.
it
Yes,
patented? Like if I have some
yes,
idea, if the person has some idea or he has
yes,
made a business
yes,
model,
yes, yes. Idea can be patented. Yes, it should be the main thumb rule is it should be new, technologically sound, and it should.
what if
Uh,
the business process or that idea relates to the service industry?
uh, Solution, say for example, software like that. Yes, that can be patented if it is new, technologically
It is
new,
not a
then it can
it
be
is not a
patented.
software, sir. It is a
Okay.
process. It is a business
Yes, a
process. For
process,
example, like
process.
Amway is there.
Yes,
Amway has a process,
yes, yes. So process can be
right?
patented. Example, I have given that of that MACD food or that Domino's food. The food process, the what the ingredients use or everything that process is under patent. Process can be patented.
Business process. But that process
Yes,
is for producing some commodity, sir. If we talk about this Domino's
yes.
or something,
That's what I
they
am
are
saying. Na, ki, that's what I am
okay.
saying.
Sure,
Ki if that
attend karo.
process. uh, that's what I'm saying. Ki that if that process is new, means not available earlier or पहले available है means available है and we are only revamping it, that is not under patent. If the process is new, it can be patented.
Like the candidate is asking, for example, the process of IPL, you know,
Process of
Indian Premier League. They have a
okay,
process of
IPL.
like,
Okay.
firstly, the bidding will be there, then there will be matches
Mm.
and these matches. So
Uh,
can that
uh,
process, is it patented or can be
no, no,
patented
it
kind
is
of
in
a
common
process?
parlance law. It is used everywhere. Say if before IPL, Australian Premier League, Big Bash League was started. So it is same process now. How it can be how it can be said as new, how it can be claimed as new process. So it will not get patented
So
if that process is new.
just like that IPL process, suppose there is some other business process.
Yeah,
There is no good being produced in IPL, right? It is
yeah, yeah,
only the
but
service we
they
can
have
say or the things
yeah, but they
happening.
have that na ki the idea can be patented
Yes.
if it is
So
new. So idea in the form of flow chart, not in mind, in the form of flow chart or in the form of any pictorial form or diagram form.
so is it easy to get it registered or there is some problem
No
coming?
research. See, in patent, 3 to 4 years almost we can take because of that research and development and in the process form. But it is easy if it is new. The my stress is on new because if the process is new, then we can get it patent. If it is found that it is very common or same process is followed in different country or same process is already registered, then we cannot get it.
Okay. And what is the time frame for getting it registered? Like, suppose a person has that idea ready with all the research and everything.
Yeah, yeah, yeah.
So, how much time will it take it to be registered?
Yeah, if everything is ready and really the process or product is genuine and all, in 1 to 2 years we can get. But due to many applications, the time has increased to 3 to 4 years.
Okay, that means if
Yeah.
if somebody wants to get that idea registered,
Yes,
it
yes.
will take around
So
3 to 4 years.
yeah, ideally we give them time ki, you have to wait for at least 3 years because what if we give the time to the SSC or applier ki 1 to 2 years, then after 2 years they themselves start calling us ki for follow up and all. That's why we in the initial stage only we tell them about 3 years and 4 years.
Okay. And who can file it? Can an individual also file the application, or it
Yeah,
has to
yeah,
be a
yeah,
company
yeah.
or something?
No, no, individual can file the application.
Okay. Regarding every kind of this intellectual property rights, is there any bar on the applicant, like individual cannot file or something like that?
No, no, no. In GI tag, there is key individual cannot file because it's place specific,
Oh,
na.
yes, it
So
is a geographical thing.
group of people can do like their local government authority and all. They can file. Either in all other there is no bar. Individual can apply for trademark, for copyright and all.
Okay. So I think this is the list is off. There's one question which is left. One of the participants is asking, sir, if we want to get a trademark or patent registered, so can we consult you? How can you give us your
So
contact
this is
details so that we can
yeah.
contact you for the same?
Yeah, yeah, you can consult me or any professional who are doing in your known area. No doubt about this. As a professional colleague, as a professional brother, I will definitely guide or consult. Yeah,
Thank you so much.
yeah. Thank you,
So
ma'am.
I should ask technical support team, should we close it or there is something left?
Yes, yes, ma'am. Thank you, sir. Thank you for a wonderful
Yeah,
session. Thank you, ma'am.
I hope I hope it add value to the listeners. Yeah,
Yes, sir.
thank you, team and ICI for this.
Definitely.
Thank
On
you,
Thank you,
behalf of,
ma'am. Thank you, sir.
okay, thank you so much.
thank you.
Yes, take support team. Yes, yes, we can.